is also related to doctrine of estate. And then where, estate in land, is vested absolutely in the individual, the ownership of such interests would naturally remain single and unshared. So similar to what you have been having before, like when you have entail or fee-tail, that's an example of an interest in land or estate in land vesting absolutely in an individual, thereby making the ownership of such interest that is vested to remain a single and unshared interest. Now, there are situations whereby estate in land may be vested in a group of persons. Estate in land may be vested in a group of persons, in which case this group of persons will enjoy concurrent interest. They will hold the interest concurrently. And then in such circumstance, they will be deemed to be holding that estate as co-owners. Two examples have been cited in this statement that I've made. One, I said that there are circumstances where estate in land is vested absolutely in individual, like we are talking about, fee simple giving to somebody, fee-tail give to somebody. And in such situation, ownership of the interest will remain a single ownership, will remain an unshared ownership. But the flip side of that is that there are circumstances when estates in land may be vested in a group of persons. That is, the estate to be vested in more than one person. It could be 2, 3, 4, or more. Now, where this happens, where this happens, what will follow, or the consequence of this will be that they will enjoy the interest concurrently, and then they will hold the estate as co-owners. When we talk about co-ownership, it will take two forms, and they are usually joint tenancy and tenancy in common. So we start with joint tenancy before we go to tenancy in common. Now, when we talk about joint tenancy, a joint tenancy is created where the land is conveyed. Please listen carefully. A joint tenancy is created where the land is conveyed or devised to 2 or more persons. It is conveyed or devised to 2 or more persons without words of severance. Without words of severance, so that from the point of view of their interest in the land, they are, united in all respects. They are united in all respects. I will repeat myself. I'm saying that joint tenancy is created where land is conveyed, where you convey land or you devise land to 2 or more persons. The conveyance is made without words of severance, so that from the point of view of interest of the two of all of them regarding the land, they are united in all respect. They are united in all respect. You can see the provision of section 3, subsection 1, paragraph A of the PCL. Provision of section 3, section 3, subsection 1, paragraph A of the PCL. I repeat myself, that joint tenancy is created where land is conveyed or devised to 2 or more persons without words of severance, such that their interest in land is such that they are united in every respect regarding their interest in that land. Now, there are 2 essential attributes of joint tenancy. Now, one of them is the absolute unity which will exist between the tenants, absolute unity that exists between the tenants, and the right of survivorship, absolute unity and right of survivorship. What I mean by absolute unity, I will explain to you in terms of the fact that they include unity of time, unity of possession, unity of interest, unity of title, and so on and so forth. Now, to drive home the point I'm making, we started by saying that where estate in land is vested absolutely in the individual, the ownership of such interest will certainly remain a single ownership or shared ownership. But there are circumstances where estates in land could be vested in a group of persons, in which case the group will have a concurrent interest in that land, and then they will hold it as a co-owners. There are two types of co-ownership that we have mentioned at the beginning of this lecture, and they include joint tenancy and then tenancy in common. Joint tenancy will explain that is created where land is conveyed or devised to two or more persons without word of severance, without any word severing their interest. And that what that means is that their interest in land is such that their interest in land is such that it is they'll be united in respect of their interest in that land, and that unity will be in all respect. That unity will be in all respect, and that there are two essential attributes of joint tenancy, which would mean that one, which will include one, absolute unity, and two, there is right of a survivorship. Please note this very importantly. So when we talk about absolute unity, number one, to constitute joint tenancy, to constitute joint tenancy, there must be presence of four unities. These unities include unity of possession, unity of interest, unity of title, and unity of time. Of course, once there is any form of severance of interest, there is unity. Sorry. What I mean is that talking about unity of interest, once there is no severance of interest, then we have what we call unity of interest. Then what that means is that all interests must be identical in size. All the interests of the parties in that land must be identical in size. That's when we say that. That's when one can say that there's a unity of interest. So talking about unity of interest, which is part of the absolute unity, we say that once there is no severance of interest, then we have been able to achieve unity of interest. And that what that means is that all interests must be identical. All interests of the parties so mentioned must be identical in size. Okay. That having been said, again, we need to also mention that where various interests vest at the same time, where the interests are vested at the same time, there is also unity of time, where the interest is vested at the same time. So summary of this is that where interests are all identical and that there is no severance of the interest, then we have unity of interest. Where the various interests are vested at the same time, then there's unity of time. But take note that it will be different if, for example, as noted by the learned senior advocate of Nigeria, Professor SAN and Professor Smith, that let us assume that if you assume that a piece of land is vested in A, B, C, and D as co-owners on the 1st of January 2010. So the land is to be vested in them as co-owner on the 1st of January 2010, and Mr. A now died. He died before the date. He died before that date, leaving Mr. K, to succeed him. So as between K on one hand and then Mr. BCD on the other hand, there's no longer unity of time, because the time of vesting interest in them has become different. And then what then happens is that K, because there's no unit of time between him or among him and then the BCD, will now become what we call tenant in common, whereas BCD are more or less joint tenants. So the example I cited is saying that it's more or less illustrating what is the effect of unity of time if the time of vesting of the interest in all of them are, if the time is the same thing, if the interest is vested at the same time, then you will still be talking about joint tenancy. But if it happens that the time of vesting interest in each of them or any one of them would be different, it then means that the one that has his own time of vesting of interest different from the other will be having common tenancy in common, while the other whose title or whose interests are vested at the same time, as exemplified in the example we cited, will be joint tenants. Now, going further, another unity that must be known is what we call the unity of title. Of course, the unity of title is that what this one is that the title must have emanated. It must have emanated from the same grantor, as opposed to where each tenant gets his own title from different grantors or different donors. So what we're trying to say is that for the unity of time, the interest must have invested in them at the same time, whereas for unity of title, the title must have invested in them through the same grantor or through the same donor. Thus, in our example that we cited, wherein we mentioned that the interest was to vest in A, B, C, D as at January 1, 2000, but A died before that time, and then he left K to succeed him. Now, as between Mr. K and BCD, when we talk about the unity of time, he does not have the time, he does not enjoy the unity of time with them. Because of that, he will become a tenant in common. And then BCD will have tenancy, will have joint tenancy. And then this also flows or more or less flows into unity of title as well, or more or less relate to, more or less have the same implication when we talk about unity of title. Unity of title, in essence, is saying that title must have emanated from the same grantor or the donor, as opposed to where the tenants will get their title from different grantors or donors. Thus, in our example that we cited above there's no unity of title between K and BCD, because the Mr. K derived his own title from the donor, which is A, from a donor, which is different from where BCD got their title. Now, the fourth one, and then.
Sorry, sir.
Yes.
Please, can you explain the unity of time once more? The example that you gave, I didn't quite understand the example.
Please let me explain to you that they almost have their title at the same time, not at different times. Are you getting my point? Hello?
Yes, sir.
Yes, their interest must have been from the same time. I get not at different times. So in the example we cited, if it happens that succession, A died and then you expected K to succeed him, if it comes to end that interest at a time different from the time that BCD have actually become interested in the land, then he's no longer a joint tenant with them, he will become a tenant in common. In the example we cited, we said that A, B, C, D were given the opportunity to be interested in a land by January 1, 2010. But before the date, Mr. A now died, leaving K to succeed him. In that example, what it means is that before they do all of the intestacy rule or whatever, if the time that K is going to be coming to possess the land or to be interested in land, time of becoming interested will be different from BCD. And what that means is that BCD, because their time of becoming interested is the same thing, while the timing of becoming interested by K is likely to be different or different from their own, K will have common tenancy, while B will have joint tenancy. In fact, what happened is that if there's any distortion in this unity, what will happen is that tenants will become tenants in common, and then their position will change from that of their joint tenancy to tenants in common. I'm not sure whether you're getting the point I'm saying.
Yes, I get it. Thank you.
You understand? So that same example, that same hypothetical example, more or less, we use to explain, unity of title, which is that the title must have been obtained from the same grantor. If for any reason one of them does not get his title from the same the same grantor that gave to BCD, then he will not be a tenant, will not be a joint tenant, he will be a tenant in common. And then we cited that in that example up there, where A died, leaving K to succeeding, leading to becoming interested at a time different from BCD, also means that the Mr. K got his title from A, whereas BCD got their title from different place. So title, unity of title must be there, unity of time must be there, unity of interest must also be there. And then you remember we said that unity of interest is to show that there is no difference of interest and that interest must be identical in size. And I also mentioned to you that there's unity of possession. And what does this one suggest? It's telling us that the tenant holds the whole, the tenant, that's the tenant, so that is any of the tenant holds the whole land. He holds the whole land in the sense that in conjunction with other tenants, in conjunction with co-tenant, is entitled to possession and the enjoyment of the whole. Possession and the enjoyment of the whole in conjunction with the others, but is not entitled to exclusive possession. He doesn't have exclusive possession of any particular or definite part of the whole. He does not have, exclusive possession of any particular or definite part of the whole. So what unity of possession says, as part of the unity, as part of the absolute unity, is that the tenants, any of the tenants holds the whole land, together and in conjunction with, its co-tenant, and therefore is entitled to possession and the enjoyment of that entire land, but is not entitled to any exclusive possession of any particular or definite part of the whole land. Now, it's important for us to note that a tenant, a joint tenant cannot sue the others for trespass. He cannot sue the others for trespass because the reason is that they are both entitled to the use and possession of that thing in conjunction with each other. So he cannot sue the other party for the other co-tenant or the other joint tenant for trespass. I'm not sure we are getting the point I'm making. You can see the case of Ipaye and Aribisala. See Ipaye and Aribisala. Now, the ratio in the Ipaye Aribisala is that the joint tenant cannot sue the other co-tenant other joint tenant for trespass because they have, he in conjunction with other, they hold the whole land, and then they're entitled to possession and enjoyment of the entire land, but not to have exclusive possession of any part or definite part of the whole. Now, let's move on. Now, the only reason why he could sue for them for trespass is that if the act that he has complained of, if the act that tenant has complained of amount to either, amount to his eviction from possession or the destruction of the subject matter of the tenancy. So the purport of what we are saying in this paragraph is that joint tenant cannot use, cannot sue the other trespass, cannot sue the other, the joint tenant cannot sue other joint tenant for trespass unless the act that is complaining about will amount to either his eviction from the possession or destruction of the subject matter of the tenancy. Of course, you also must note that a third party that is let into possession by a joint tenant cannot be ejected by any other joint tenant, nor can a joint tenant sue for, account. Of course, he can't sue for account. But they are saying that for that, you can see the case of Kuri and Kuri. Kuri is spelled K-U-R-I, K-U-R-I. But even though he cannot sue for an account, he would the position in the Act of 1705 is that an action can be brought against him if he receives more than his own share of the rent. Please give me 1 minute, please. 1 minute, please.
Sorry, sir, we cannot hear you very well again.
1 minute, please. Give me 1 minute, please.
Oh, sir, we cannot hear you again, sir.
He said I will give him 1 minute.
Okay. Hello. Hello.
Yes, sir. Can hear you.
Okay. What is it that you did not hear?
I hear you, sir.
You said you did not hear something. Do you want me to take it again? You want me to take it again? Hello? Hello?
Yes, sir. Yes, sir.
Okay, don't worry. I'll take unit of possession again. So I'm saying that unit of possession suggests that a tenant holds, he holds the whole land in the sense that in conjunction with his co-tenant, is entitled to possession and to the enjoyment of the whole land, but is not entitled to, exclusive possession of any particular or definite part of the whole land. It also tells us that that joint tenant cannot sue other joint tenants for trespass unless the act that is complaining about will amount to either its eviction from the possession or that it will amount to destruction of the subject matter of the tenancy. Also, it is said that where a third party is lent to possession by a joint tenant, that third party cannot be evicted. It cannot be ejected by any other joint tenant. And then you can see the case of Kuri and Kuri. And I also mentioned that a joint tenant cannot sue the other for joint tenant, only that the provisions of Admission of Justice Act of 1705 will prevent, a joint tenant from taking more than, his own share of the land or share of the rent. So now, and then that will make it possible for you to bring to make it possible for a joint tenant to bring an action against a joint tenant who has received more than his own share of the said land or whatever is accruing from the land. Now, I also must let you know that this one is important. It's called the doctrine of jus accrescendi. The jus accrescendi is spelled J-U-S, accrescendi is spelled A-C-C-R-E-S-C-E-N-D-I. It's a Latin word meaning that where a joint tenant is created or where joint tenancy is created, and one of the joint tenants dies without having obtained a separate share in his lifetime, please note very importantly, his interest is extinguished and then will accrue to the surviving tenants as opposed to his personal representative under the rules of jus accrescendi. Jus accrescendi rule also applies to joint tenancy, and it says that where a joint tenancy is created and one of the joint tenants dies without having obtained a separate share of his own, a separate share during his lifetime, his interest will be extinguished and then accrue to the surviving tenant as opposed to the as opposed to his personal representative under the rule of jus accrescendi. Now, how do we determine joint tenancy? They say that the position of law or the rule is that anything which creates distinction, anything that creates distinction between joint tenants, will sever the tenancy and convert it to tenancy in common. Please note very importantly, anything which creates a distinction between joint tenants, will sever the joint tenancy and convert to tenancy in common. Of course, you can see the case of generally you can see the case of Williams and then Hensman, William and Hensman, C. Menkiti, and then Agina. Hensman is spelled H-E-N-S-M-A-N. You can see Menkiti is spelled M-E-N-K-I-T-I, against Agina. Agina is spelled A-G-I-N-A. So C. Williams and Hensman, and then C. Menkiti and Agina. You can also see, you can also see Union Bank of Nigeria Limited and another versus Jimba. See Union Bank of Nigeria Limited against Jimba to illustrate or more or less support the position that anything which creates a distinction between joint tenants will sever the tenancy and then convert to tenancy in common. Are we together? Are we together? Are we together?
Yes.
So I have a question.
Yes, sir.
So I have a question.
Okay. Yes, sir.
So I have a question.
Yes, please ask it.
Okay, so when let's assume I was in a joint tenancy with some people and I asked for my share to be separated from the joint tenancy, would that alter the entire joint tenancy that was created, or it only just removes me from the equation to after
No,
the
what the law says here, what the law says by the assertion of Professor Smith, and then which is asserted by Professor, is that it will eventually alter it if you get eventually, because it says that anything that creates a distinction between joint tenants, would certainly do what? Would certainly serve as a tenancy, serves as will sever the tenancy and then to convert it to tenancy in common.
Okay, so for everybody. All right.
Yes.
Thanks, sir.
All right.
Thanks, sir.
So, and the
Please, I have a question.
Okay, please do.
With regards to what the person that just spoke mentioned, you said that anything that creates a distinction will affect the entire tenancy in common. But then
Yes,
in the example above, as regards unity of time,
yes,
when K obtained interest,
because that at that time, ultimately what will happen to all of them is that thing will be converted to tenancy in common. That's what will happen to them, because they have had a distinction between the two of them, between K and the rest of them. It will ultimately lead to converting that joint tenancy to tenancy in common.
Okay, sir. Thank you very much.
You understand what I'm saying? Yes. Because if you follow the opinion of Professor Smith, SCN here, he's saying that whenever there's a distinction, he did not qualify it. It says whenever there's a distinction between the joint tenants, it will sever the tenancy and then convert it to tenancy in common. You understand what I'm saying?
Yes, I do.
Okay, so ultimately, it may not happen immediately, but what ultimately follows a distinction a distinction that could happen in their future is that it will certainly convert it to tenancy in common. So, and then we say that the tenancy in common, the joint tenancy may be severed where there is an alienation by a joint tenant. Are you getting my point? Since the alienee and the other joint tenants hold, by virtue of different titles. So if any of the joint tenants take steps to alienate, then the alienation would have actually, to a larger extent, create different title for each of them, and then it would certainly, lead to converting joint tenancy to anything that operates to create distinctions between them will certainly convert joint tenancy to tenancy in common. Of course, they say that if one of them, by consent of the other, acquires a larger interest, such as where a joint tenant in respect of a life estate acquires, a fee simple in reversion, or where one joint tenant releases its interest to the other. So, anytime that there's an alienation, anytime there is an alienation by any joint tenant, anytime there is a acquisition of a larger interest by any of the joint tenants, anytime there's partitioning, which in effect makes the former co-tenant to separate, owner of a portion of the land, then joint tenancy will terminate. So the summary of what we are saying here is that when you are determining joint tenancy, note that anything that will create distinction between joint tenants will sever their tenancy, and convert to tenancy in common. However, they are saying that this determination of joint tenancy can occur in any of these circumstances where there is an alienation by any of the joint tenants, or that where there is a acquisition of a larger interest by any of the joint tenants, or where there is partitioning of the set. So by alienation, acquisition of large interest, partitioning, all of this will lead to joints, will lead to determination of a joint tenancy. Also, please note that we say that the joint ownership may also be terminated by sale, and the joint title transfer into the purchaser with the land vesting in the latter as a single owner. So anything that has nature of alienation, anything that has a nature of acquiring alienation by any of joint tenants, and that has the nature of acquiring larger interest by one of the co-tenant, one of the joint tenants, anything that has the nature of partitioning, anything that has the nature of anything that has the nature of sale. So any form of alienation, any form of acquisition of larger interest by joint tenant, any form of partitioning, any form of sale would naturally lead to the determination of a joint tenancy. Okay. Now, let us come to tenancy in common. Let us come to tenancy in common. Want to come to tenancy in common? Tenancy in common is created in any of these three ways. Usually created in any of these three ways. Number one, where the land is limited to, where the land is limited to two or more persons with words of severance. Remember that in joint tenancy, there's no word of severance. There's no word of severance in the first one. There's absolute unity of time, absolute unity of interest, absolute unity of title, and absolute unity of possession. Of course, remember that interest must be identical in size, but here joint tenancy is saying that there's no severance. But here when creating tenancy in common, where the land is limited to two or more persons with words of severance, there's words of severance showing an intention that the donees or the grantees are to take separate shares, then you have created a tenancy in common. Where land is limited to two or more persons with words of severance showing an intention that the donees are to take separate shares, then what we have created is tenancy in common. Such expressions like equally to be divided, like to be divided equally among, or share alike, have been construed as words of severance, creating tenancy in common. So when you have words like equally to be divided, equally, that is, it is granted to them equally, or granted to them to be divided, granted to them to be equally divided, or to be divided among them, or to share and share alike. The kind of tenancy that you are creating is tenancy in common. And the distinction between this tenancy in common and joint tenancy is that the first one, joint tenancy, does not make use of words of severance. The common tenancy in common makes use of words of severance. And then I said one of the three ways by which it can be created, identified by a learned Professor Smith SAN, is that where land is limited to two or more persons with words of severance, showing an intention that the donees are to take separate shares, then we have created tenancy in common. Such expression like equally to be divided, to be divided equally among, or share and share alike, have been construed as words of severance, creating tenancy in common. Okay. Now, you can also have tenancy in common created in this scenario. Number two, where there's an equitable assumption against joint tenancy. There are circumstances, not limited, not less than two, where equitable equity will presume against joint tenancy. There's a presumption, there's an equity presumption against joint tenancy, and then in that circumstance, tenancy in common will have been created. One of those circumstances when equity we presume against joint tenancy is one where two parties have contributed money to buy a piece of land, and one has contributed more than the other towards the purchase price, or where the property is held, by a partnership. So where there's a partnership, or where the two parties have actually, where there's a partnership and you have bought the land, their partnership, you have bought the land through your partnership, or that you have both parties have contributed to the purchase of the land, and then in the purchase of that land, one party has contributed more than the other. The doctrine of equity is that there will be a presumption against joint tenancy, in which case the rule of joint tenancy will no longer apply in any of those circumstances. So if, for example, me and you have actually planned to buy a piece of land, and then the plan is that we plan to buy a piece of land, but I've contributed more than you have contributed, then what it means is that there will be presumption against a joint tenancy being created. And what will have been created is tenancy in common. The reason why we emphasize this is because the consequences of each of them will be different. Because in joint tenancy, there's jus accrescendi. Jus accrescendi means that it means the rules of survivorship. It is survival among the tenants that will remain, that will take the remainder of the estate. Whereas in a tenancy in common, it is the representative of any one of them who is deceased that will take what is left for that person or his own share of the estate. Now, that having been said, where one joint tenant disposes his own interest to a stranger or acquires an interest greater than that of his co-tenant, like we mentioned, remember that we said that will create a distinction between the two of them. Any of these circumstances, like where they have sold, they have all sold and transferred their title to a purchaser who will replace them and now have a single ownership, or where there's a partitioning, or where one of them has actually alienated his interest in favor of the third party, or where one of them has acquired interest more than the other in that land. Then what that means is that because where he acquires more interest than the other, then they no longer have unity of interest. Their interest is no longer identical in size. And then in any of those circumstances, what will have happened is that there's a distinction between two of them. And as we are reminded, by Professor Smith, he said that any of such distinction would be what will sever the joint tenancy. And that is what will happen here. In any of those cases where the distinction is created among the joint tenants, then what we'll have is co-tenancy. An example of such place is where one joint tenant disposes of its interest to a stranger or acquires a larger interest than that of his co-tenant. Now, generally, remember that in common law, in tenancy in common, the absolute unity which exists among the joint tenancy is lacking. It's missing. It's not there. Okay. The only unity between tenants the only unity between tenants common is the one of right to possession. The right of possession. Of course, the rule of survivorship has no application under tenancy in common. So that when one tenant dies, his shares, of course, goes to his personal representative and not to the surviving tenant. When tenants die in joint tenancy, his own share goes to the survivors. While in the case of tenancy in common, the share of that man who dies goes to his representative. So that having been said, let us also note that tenancy in common may be determined, and be converted into separate ownership through sale or through acquisition by one tenant of shares vested in his co-tenant, on his co-tenant. So if you sell, or if other one acquired the right of other person, co-tenancy in common will also be terminated. But note,
Sorry,
very
sir.
importantly, yes.
So I didn't get the part of tenancy in customer in tenancy in common may be converged to.
No, tenancy in common could disappear if there's a sale. I get my point. Or if one of tenants acquires more interest in that land than the other. Did you get what I'm trying to say?
Yes, sir.
Okay. If they decide to sell it to a third party, or that one that acquires a larger interest, like an interest of 2, 3 or more of them, then it becomes determined. Now they are now telling us that we should note the effect of the provision of section 3, subsection 6 of PCL. And of course, in relation to tenancy in common, you can see the case of STEAD and STEAD. STEAD is spelled STEADS, and against STEADS. Now that having been said, we say that we should note the effect of section 3, paragraph 6 of the Property and Conveyancing Law and corresponding provisions of property legislation in other states of Nigeria. Some of those states have also made provisions that legal estates held in tenancy in common have been abolished in those states where the laws apply. So in PCL states and so those other states, I get to my point, where they have made corresponding property legislation, they have sort of abolished what we call tenancy in common. Now, whether they have abolished what is called tenancy in common, and a conveyance of land to any person in tenancy in common shall take effect as if the land was expressed to be conveyed to the grantee, to be conveyed to the grantee if there are more than 4. If there are more than 4, are we together? If there are more than 4, to the first 4 that is named conveyance as joint tenant upon statutory trust for sale for themselves and on behalf of the other co-tenants. I will explain this to you. What they are saying is that a conveyance, foremost, section 3, subsection 6 of the PCL says that we no longer have tenancy in common. It has abolished it. Then there's also corresponding provisions in other state legislations on land that are applicable to show that they have also abolished tenancy in common. Now, the position of this PCL and then position of other laws, other land legislations in other states is that when a conveyance of land, is made in tenancy in common. Hello, who is that? Please let's keep quiet. Now that when conveyance of land is made in tenancy in common to any person, they said that the effect of the law now is that it shall take effect as if the land was expressed to be conveyed to the grantees, as joint tenants. But if there are more than 4, then it will be deemed that it has been conveyed to the first 4 that is named in that conveyance, as joint tenant, who will hold in statutory trust for themselves and on behalf of the other co-tenants. Effect of statutory trust for sale is that the power that is given to them in respect of that land is definitely to sell the land, and the parties are no longer interested in the land. They are interested in the money, the proceeds of the sale. I repeat myself that tenancy in common has been abolished. And then if you look at section 3, subsection 6 of PCL of Western Region, it has abolished it. There are other corresponding property legislation across the states that have also done the same thing. And the effect of it is that any conveyance of land to anybody in tenancy, in tenancy in common, he says that it shall take effect as if the land was expressed to be conveyed to the grantees as joint tenants. And if there are more than 4, it will be conveyed to the first 4. If there are more than 4, it will be conveyed to the first 4, who will hold as joint tenants upon statutory trust for sale for themselves and on behalf of the other co-tenants. So the effect of this is that when this thing is given to any people, the number of persons, and there are more than 4, it will reckon with the first 4 persons as the person to whom the thing is transferred to as joint tenants, and then their joint tenancy is such that they will hold it. They will hold it as statutory trust for sale. So the effect of this is that the thing is saying that if I give the land to people in joint tenancy in common, then it will be deemed that it's joint tenancy. So it also shows that even if I give it to them in tenancy, even if they are deemed to be a joint tenant, what will happen eventually to them is that those joint tenants are deemed to hold it in as statutory trust for sale. And then when something is held in statutory trust for sale, it then means that the interests of the parties are no longer, in the land. Their interests are no longer in the land, but their interest is in the proceeds of the sale. Now, the next thing we are going to be
Sorry, sir.
Yes, I can hear you.
Yes, sir. If there are more than 4, what happens to the other people? They don't have any interest.
Oh no! If they have, no, they have. You see, this is a statutory trust. When we, the meaning of statute. This is a statute created. This is a trust created by law. So, what happened is that we are saying that what happens is that if you create a joint tenancy, statute had actually turned it to, if you create tenancy in common, what we are saying is that if you create tenancy in common, statute will turn it to a joint tenancy. And then what we are now saying that if your joint tenancy will still subsist, it will be deemed to be that statutory trust for sale has been created. Statutory trust for sale has been created in favor of the first 4, even if there are more than 4. So those people who are trustees for sale would hold it in trust for the rest of them. And then what that means is what statutory trust for sale means is that when it is created, the parties are no longer interested in the land. What they will be created for, what will be interested in is what we call the proceeds of the sale. So the effect of this is that your tenancy in common that you created would more or less be converted to tenancy in common, joint tenancy, and your joint tenancy that subsists will operate like a statutory trust for sale. Like if statute has created trust for you people that hold the joint tenancy. In such case that those trustees that are holding the land among you will be the one to do what? To sell and then keep the proceeds to be shared among you. At the point that the joint tenancy has been converted to statutory trust for sale, the interests of the parties are no longer in the interests of the parties are no longer in the or rather the interest of the parties is no longer in the land, but in the proceeds that they will get when the land will be sold and the proceeds will be shared among them. I'm not sure they are getting the point I'm making now.
Yes, sir.
Okay. Can I move forward?
Excuse me, sir. Please, I have a question before you move forward,
yes,
sir.
Please, go ahead.
So, sir, I would like to ask. So, in a situation where more than 4 tenants come together to see conveyancing of land, how are the first 4 tenants, co-tenants, determined? Like, who determines who the first 4 are, and on what basis are they determined, sir?
No, the way they are listed now, they said the first 4.
Oh, okay. Just essentially how they are listed.
The first 4 to be named in the conveyance. It's just for the purpose of convenience. It's for convenience. You understand what I'm saying? Hello?
Yes, I do. Yes, I can, sir.
Exactly. So they said the first 4 to be named. So those people, a statute will have created trust for them. that, well, all this wahala, stop it. We'll create a trust for you. That trust means that these people will hold it for the benefit of the rest. Sell it. When you sell it, share the money. So the interest now is no longer the land. It is what's it called? So because all we are tracing before, there are common law rules that affect joint tenancy and then tenancy in common. But statutes have come to modify them to say that no longer create a tenancy in common. When you create one, well, our law will convert it to tenancy, to joint tenancy for you, and your joint tenancy itself is even as good as statutory trust for sale that has been created for you. So when it becomes a statutory trust, which is for sale, the essence of it is that sale must take place. When the sale takes place, or even before the sale takes place, what you have in the land is not the land. The interest you have in the land is not the land, but the proceeds of the sale when it's specially done. And they think that if the trustees will be for themselves and on behalf of the other co-tenants. Now, what is the relationship between we have to finish this one today. Don't let us drag ourselves back again. Now, because we still have a trust for sale, we still have concept of settlement too. Now, Land Use Act, we are not going to be looking at the relationship between the junction of estate and Land Use Act. The Land Use Act, have more or less vested all the radical titles in land in a state of Nigeria, in the governor, who is having, who is having control over the land in that state. So I repeat myself, Land Use Act 1978, having vested all the radical title of land in the territory of a state, in all the territory of a state in Nigeria, in the governor of that state. And therefore, what it does, having granted or having given the radical title to the governor of that state, what is left for individual is right of occupancy. It is before now that we will enjoy radical title. What is left is usufructory right. That is right of occupancy. Now, the argument today appears that the act will have rendered nugatory the study of doctrine of estate, and the argument is more or less premised on the following justification. I repeat myself that the Land Use Act of 1978, while treating the relationship between the doctrine of estate and the Land Use Act, appears to have vested the radical title of the land in any territory of a state, in the governor of that state, and thereby leaves only the individual with right of occupancy. And then this has actually, provoked an argument, appearing today, to the fact that the act has more or less rendered nugatory, the study of, doctrine of estate. And if you check very well, you will see that the argument can be substantiated by the following justification. Number one, Section 1 vests the ownership of land comprised in a state, in the governor of the state. And it does argue that, ownership is now vested in the governor. It cannot remain in the individual. So all forms of estate will merge in the governor. All forms of estate merges in the governor, because all land is now vested in the governor by virtue of Section 1 of the Land Use Act. Now, it goes on to Section 5, and as well as Section 6. Section 5 is saying that, governor is empowered to grant statutory right of occupancy to individuals, suggests that no individual, from the point of view of the governor, can grant any right or interest in the land beyond statutory right of occupancy. So we are saying that Land Use Act has granted the land in a state, in a governor, and that the effect of this is that it has left the individual with a right of occupancy, with the consequences that it will render nugatory all the doctrine of estate, based on the following justification. Number one, the Land Use Act has vested the land in the governor, and that all estates will merge in him. Now, 2, the provision of section 5 of the land use act is that it empowers the governor to grant statutory right of occupancy to an individual, suggesting that no individual can, at least from the point of view of the governor, grant any right or interest in the land beyond right or statutory right of occupancy. So nobody can grant retail, nobody can grant retail or free simple. You can no longer grant free simple, you can no longer grant retail. That's what it means by the provision of section 5. In the same vein, that is governor of a state. Section 6 also empowers local government to grant statutory right of occupancy to a citizen with the same result under section 5. So local government, by virtue of section 6, can grant customary right of occupancy to citizens with the same result as we have under section 5, where the governor can grant rights of occupancy. So what you are saying is that no individual can grant you any estate that will go beyond or that will extend beyond statutory right of occupancy. Are we together? That can extend beyond statutory right of occupancy, and therefore a grant of any estate in the form of free simple or in form of retail would not be entertainable under the provisions of Land Use Act by virtue of section 1, which grants the entire land and then deposit that land in the domain, in the control of the governor, giving the ownership over the land, and then now giving right under section 5 to say you can grant not beyond, you cannot grant beyond right of occupancy, statutory right of occupancy. Then if the governor cannot grant more than right of occupancy, how is it possible for anybody to grant an estate or interest in any land that will extend beyond or that will be over, that will extend beyond right of occupancy? So the same way, the local government is also empowered to grant customary right of occupancy in section 6 of Land Use Act to citizens, which will mean that the results that will be achieved in section 5 by virtue of section 5, the same result that will be achieved by virtue of section 6. Now, again, if you check your land law very well, you will see that this one is talking about statutory right of occupancy granted expressly granted by virtue of section 5 by the governor, while the customary right of occupancy is the express right granted by the local government. Now, if you check section 34 and section 36, they are talking about deemed grants. So they say that by that the provisions of section 34 and section 36, which tend to preserve existing interest, they preserve what? Existing interest on land, now have same effect as actual grant as section 5 and section 6 of the Act, to the extent that the governor or the local government is deemed to have granted right of occupancy, as the case may be with regards to such existing interest on land. Please, I take it again that the provision of section 34 and provision of section 36, of course, what they do is that they preserve the existing interest in the urban region for section 34. Section 36 more or less preserve the existing interest on land in the non-urban region. Of course, they now say that the effect of the two of them is that for section 34, it will have, the same effect as if there's an actual grant under section 5 by governor in the urban region, and then it will be deemed, the deemed right preserved or protected under section 6 for land in non-urban region will have the same effect as if there's a right granted to you by the local government in the non-urban region. To the extent that the governor of the local government is deemed, they are deemed, not expressly. 5 and 6 is an express grant of statutory right of occupancy. Section 34 and 36 is a deemed grant of right of occupancy. So section 1 says, we're saying that what is it called? Deemed appears to have been abolished by virtue of the fact that section 1 of the Land Use Act has taken all ownership and given to the governor, and the section 5 gives him right to give express grant, which is a right of occupancy. Section 6 also says that the local government can make excess grant in respect of customary right of occupancy. But there's also a deemed grant of statutory right of occupancy. A deemed grant of statutory right of occupancy under section 34 and 36. So what they're saying is that whether your right is deemed grant under section 34, whether your right is deemed grant under section 36, what you can have is statutory right of occupancy. This section 34 and 36, they have some implications that I'm going to explain to you as you go on along the line. So different from what is the implication, as we have seen in section 5 and section 6. So note very essentially that reason why we say that the doctrine of estate has been rendered nugatory is by virtue of section 1, which vests all land in the governor. Section 5, which gives him right to give not more than statutory right of occupancy expressly in respect of land in the urban region, and also empowers local government to give customary right of occupancy in respect of land in the non-urban region. And that if these two people cannot grant, if this land have invested in him, and he cannot grant you more than statutory right of occupancy, it is not possible for you to give any right that is more than what has been granted to you. And that's why we're saying that it has rendered the doctrine of estate very nugatory. However, we said that also this deemed right that is preserving your interest in the land over the land, the right that you have acquired before the commencement of land use act is being preserved by section 34 in the urban region, and is being preserved by section 36 in non-urban region. The right that is deemed in your favor, that is deemed to have been granted to you by virtue of this section 34 and 36, is also deemed, deemed right of occupancy. It's a deemed right of occupancy. So you also cannot, whether expressly granted to you under section 6 or section 5, whether it is deemed to have been granted to you under section 34 or section 36, what is granted to you expressly in section 5 and section 6, and what is deemed to have been granted to you under section 34 or section 36 is more or less right of occupancy. You cannot grant more than what you have. What you have, what you don't have, you cannot give. And that's why we're saying that is justification for saying that the doctrine of estate seems to have been, rendered nugatory by these provisions. Now, oh God, we can't proceed more. Let us leave it till Thursday. We'll continue from there. Because if I start to explain this, you don't understand. So, ladies and gentlemen, hello? Hello? Are you people there?
Yes, sir. Yes, sir.
So we're here.
Don't
Can
worry,
hear you, sir.
It's just 1 minute to the end of the lecture. Let's leave it till Thursday. We can continue from there. But note where we stop, please.
All right, sir.
Do you have any problem?
Thank you, sir.
Do you have any problem with this?
Thank you, sir.
Yes, sir. We understand, sir.
Sir. Bye, sir.
Bye-bye.